Good evening. How's everybody doing on a Monday? Yom Sheni. Let's light up the darkness. Big day. Double daf. Doing 2 pages today. They're pretty short and we have a head start from yesterday, so very doable. And that'll help us catch up a little bit. We're 3 pages behind. So if we can do doubles on 3 days, we'll be caught up. Who's in the house? Bill in Mid-Missouri, Paul in the Great Northwest, Clarice wishing everyone a good evening, Shandora in the Bronx, Renee in Indiana, Joseph in Massachusetts, Bella in Florida, Lucy in Minnesota, John in Maine, Ryan in Florida, Belle, shalom to all, thanks, Salinina. The dogs are all set for their lesson. Love it. Marjorie in Georgia, Lynn in North Texas, Aoife checking in from Florida, and wishing everyone a meaningful Memorial Day. Let's dedicate today's learning to all of those who made the ultimate sacrifice that we might enjoy the liberties and the peace that we enjoy this day, this opportunity to learn together. May our learning today accrue to the merit of those who made the ultimate sacrifice on our behalf, and we remember them on this Memorial Day. Our dafs, our pages, are 10 and 11 here in Tractate Gittin, the 19th volume of the Talmud. Generally, the laws of divorce and the bill of divorce. We're working our way through chapter 1, and today we open Mishna number 3. This is about halfway down the page on 10a. Mishnah number 3, any document that has a Samaritan witness, singular, a Samaritan witness, signed on it is invalid, except for bills of divorce and bills of manumission that were used to free slaves. An incident occurred in which they brought a bill of divorce before Rabban Gamliel in the village of Otnai, and its witnesses were Samaritan witnesses, and he deemed it valid. Who were the Samaritans? We've covered this before, but the Samaritans were a non-Jewish people that were brought into the land of Israel after the first temple was destroyed. The northern kingdom had already been conquered earlier by Assyria. The southern kingdom was Judea. After the first temple was destroyed and the Babylonians took the Jews away, it was like an unsettled land. So the Assyrians brought a people in to occupy the land. And these came to be known as the Samaritans because they were occupying this land, this part of the land of Israel known as Samaria. Because they were not Jewish, they were idolaters. But once they were in the land of Israel, things started to go very badly for them, including they were attacked by lions. There was some kind of a plague of wild lions. And they came to understand that for some reason, an idolatrous people dwelling in the Holy Land will be spit out of the Holy Land. And so they converted to Judaism, but it wasn't a wholehearted, full-hearted conversion, right? It was more of a conversion under duress. And so what was good about it was they abandoned idolatry. They became monotheists. They did subscribe to the written Torah mostly, but they didn't subscribe so much to the oral tradition, right? The Torah Shebaal Peh, which of course is what the Talmud is all about, right? The Mishnah and the Gemara together are a record of the oral tradition that stretches back all the way to Mount Sinai. So in not subscribing to the oral tradition and the authority of the rabbis who transmit the oral tradition, the Samaritans took themselves out of Judaism, out of normative Judaism. Judaism without the oral Torah is not Judaism. And so, because they were fairly meticulous in the Jewish practices that they did adopt, for certain areas of the law at certain times in history, they were deemed to be valid witnesses, or, that you could buy from a Samaritan. But for the most part, they were mistrusted, and eventually the sages decreed that they were simply Gentiles, right? They weren't Jews because they had a kind of partial Judaism. A partial Judaism is not Judaism. And so here we're examining, now that we're talking about bills of divorce and the need to have witnesses witness the signing of the bill of divorce by the husband, and other witnesses witness the delivery of the bill of divorce to the woman. Sometimes those are the same witnesses, often they're not. The couple doesn't really want to get together, they're divorcing, right? So he signs in front of a pair of witnesses, and then that get is delivered and handed to her in front of witnesses. Maybe the same witnesses, maybe other witnesses. The question here is, can those witnesses be Samaritans? And then more broadly speaking, and we'll get to this a little bit in this Mishnah and the next Mishnah that we're also going to today, could the witnesses simply be Gentiles? Right? So here in this first Mishnah, any document that has a Samaritan witness signed on it, not valid, except for bills of divorce, except and bills of manumission to free as slaves. And there was an incident in which they brought a bill of divorce before Rabban Gamliel in the village of Adnai, and its witnesses were Samaritan witnesses. So maybe it is that if there's even one Samaritan witness, any Jewish contract is deemed invalid under Jewish law, but there can be a single witness on a bill of divorce or a bill of manumission, and it's valid. And it seems that Rabban Gamliel even accepted a bill of divorce when it had two signatures of Samaritan witnesses. Let's see if we're understanding that correctly. Here comes the Gemara. The Gemara asks, whose opinion is expressed in our Mishnah? It is not the opinion of the first Tana, nor that of Rabbi Elazar, nor that of Rabban Shimon ben Gamliel, as the Gemara will now explain, because they have said things in other places that contradict what we find in this Mishnah. Right? So, as it is taught in a Baraisa, in the Tosefta of Pesachim, the matzah of a Samaritan is permitted on Passover. Now, that's a pretty good endorsement of the Judaism of the Samaritans, that their matzah, when we are the most meticulous and exacting, that matzah has to be properly prepared matzah, that there can't be any chametz in the house or any kind of leavening involved at all. So you would think that if there's some kind of a question of were the Samaritans really Jewish or not, we would never accept their matzah to eat it on Pesach, on Passover, and yet we have this baraisa that says that the matzah of a Samaritan is permitted on Passover. Why? Because there's no concern that it might be leavened. And a person fulfills his obligation to eat matzah on the first night of Passover with this Samaritan matzah. And Rabbi Elazar prohibits the consumption of the matzah of a Samaritan. Why? Because the Samaritans are not well versed in the details of the mitzvahs, of the commandments. And Rabban Shimon ben Gamliel says, on the contrary, with regard to any mitzvah, any commandment that the Samaritans embraced and accepted, they are more exacting in its observance even than the Jews are. So they didn't accept all the commandments, but the ones that they did accept, they were meticulous to observe correctly. Now the Gemara elaborates whose opinion is expressed in the Mishnah. If it is the opinion of the first Tana in the Baraisa, then even other documents should be valid when signed by Samaritan witnesses, by ruling that one can fulfill his obligation with Samaritan matzah. The Tana of that Baraisa, right, the rabbi of that Baraisa, apparently holds that the status of Samaritans is the same as that of Jews. If we can eat their matzah, okay, so they're Jews. So if so, that should be their status with regard to their testimony on any document. Why are we going to disqualify, a deed for a transfer of a piece of land that was witnessed by a Samaritan because they're not Jewish, when we're saying that their matzah is valid? You would think that their signature should be valid on any Jewish document. If the opinion in the Mishnah is that of Rabbi Elazar, who expresses the concern that Samaritans are not well versed in the details of mitzvahs, well, then they should not be fit even to sign a bill of divorce. Why are we going to make a special exception and say, well, Samaritans, we don't accept their signatures on any document? accept the bill of divorce. A bill of divorce, as we've seen so often, is an extremely important document. If there's something invalid about it and a woman relies on it that she's divorced and remarries another man and has children with him, and then it turns out the divorce was not valid, so the children of that second union are mamzers, which is a tragic situation. So how are we going to be lenient and allow Samaritans who are not allowed to sign other Jewish documents that we do allow them to sign a bill of divorce? What's going on here? And if you would say that the opinion in our Mishnah is that of Rabban Shimon ben Gamliel, and the Samaritans embrace the mitzvah of bills of divorce. So maybe he said, right, the mitzvahs that they do embrace, they observe them meticulously. So maybe the Samaritans were very exacting when it came to the law of a Jewish divorce. And that's why we would allow them to sign the get. And that's right. But they do not embrace this mitzvah associated with the subject of other documents. Maybe that's the reason they don't embrace Jewish law when it comes to contracts generally, but they did embrace Jewish law when it comes to the bill of divorce. And maybe that's why we allow them to sign a bill of divorce and not other documents. Could that be the explanation? Wait a minute. Right, if they embrace and accept the mitzvah associated with the bill with the subject of the document, so even with regard to other documents, their testimony should be valid. And if they do not embrace and accept the mitzvah associated with the subject of document, they should not be fit to sign a bill of divorce. I'm sorry. And if you would say that the opinion of the Mishnah is that of Rabban Shimon ben Gamliel, and we're saying that the Samaritans embrace the commandment regarding the bill of divorce, but they do not embrace the commandments with regard to other documents. So the same would hold true even if two Samaritan witnesses, right? We said that we're going to allow a bill of divorce or a bill of manumission if it has one Samaritan signature. But according to Rabban Shimon ben Gamliel, if we can trust Samaritans with regard to one of the commandments that they embrace because they observe it meticulously, so why are we going to say that we can only have one Samaritan witness signature on a bill of divorce, but not two? I mean, if they're so exacting and meticulous in their observance, so then two witnesses should be okay also. So what's going on here? And the Gemara answers, actually, the opinion expressed in our Mishnah, right, that Samaritans can't sign other documents, but it's okay to have one Samaritan witness on a bill of divorce or on a bill of manumission. So whose opinion is that? It's Rabbi Elazar. And as a rule, one may not rely on the testimony of a Samaritan on a document. And the Mishnah is referring to a case where a Jew signed the document last. Now we're on 10b. As if not for the fact that the Samaritan was one devoted to the meticulous observance of commandments, and which makes him a chaver, right? That normally means a friend, a companion. But in Talmudic parlance, when we talk about chaverim, or plural or singular chaver, this is somebody who's meticulous in his observance of mitzvahs, right? And so one pious person can trust another pious person to have tithed properly, etc., so they could eat each other's produce, etc. That's a chaver, right? A chaver is even more meticulous. They would only eat, even though they're not priests, a chaver would only eat food in a state of ritual purity. So here we're saying perhaps this Samaritan was devoted to meticulous observance of the mitzvahs, and so the Jew who signs after him on a bill of divorce, right? There's only one Samaritan allowed before we disqualify that get. But what they're saying is the Jew who does sign the get along with the Samaritan basically is attesting to the fact that the Samaritan he signed with is a Samaritan who can be trusted to be meticulous with the commandments. Otherwise, he wouldn't have signed after him, right? We're talking about a case where the Samaritan's signature comes first and then the Jew's signature comes after it. And what we're basically saying is the Jew who signed after the Samaritan is communicating with us through the placement of his signature on that get that we can trust the Samaritan, that he was somebody who was meticulous with respect to commandments, at least the commandment of the bill of divorce. Therefore, one may rely on the Samaritan signature in this particular case, where his signature comes first and then the Jew's is after it. In this case, the Gemara asks, whoa. If so, that the Mishnah is referring to that case where the Samaritan signs and then the Jew signs, then even other documents should be valid as well. If that's what you're saying, that we're talking about that kind of a case where we're going to accept a single Samaritan signature because the Jew who signs after him is basically attesting that that Samaritan was particular with regard to the mitzvahs, then why not allow the same philosophy, the same ideology, the same concept to operate for any kind of document under Jewish law? So the Gemara says it must be that that's not what's going on. Rather, this is not the case with regard to other documents, as we say that the fact that the Jew signed last does not prove that this Samaritan was a chaver, someone meticulous in his observance, as perhaps in signing last, the Jewish person was leaving space above his signature for one who was older than he, in deference to an elder. And instead, he was waiting for an elder to come and sign above him, but instead a Samaritan came and signed in that spot. So the Gemara asks, well, if that's your reasoning, then here too, why would we trust a Samaritan? Maybe the Jew just left a space for an elder to come and sign above him, and then a Samaritan came and took that spot for his signature. So why are we going to allow a get with a Samaritan signature on it? Rav Papa says, that is to say, an explanation of the difference between bills of divorce and bills of manumission versus other documents, right? Or other documents, no Samaritan signature allowed, or it's disqualified. Bills of divorce and manumission, one Samaritan signature is permitted. Why do we have this difference according to Rav Papa? The difference is that the witnesses of a bill of divorce and a bill of manumission may not sign without the other. Rather, each witness signs in the presence of the other. The difference about a bill of divorce and a bill of manumission versus other kinds of documents is that in the bill of divorce or the bill of manumission, all the witnesses have to be present at the same time when they sign the document. You can't, let's say you're the husband who's creating this bill of divorce, so you sign your name in front of a witness, right? And, then he witnesses and signs, and then you take it to another person and say, look, this is my signature. This is my bill of divorce. It was signed by Joe yesterday. Now, will you sign it also? No good for the bill of divorce. Everyone has to be present at the same time when it is signed. Whereas with, let's say, a purchase, a deed of purchase for a piece of land, that you could get the signatures of witnesses at different times. So Rav Papa is saying that's the difference. So the Gemara asks, what is the reason that the witnesses must sign a bill of divorce or a bill of manumission all at the same time? And Rav Ashi says it is a rabbinic decree issued due to a case where the husband says, all of you are witnesses on this bill of divorce. So in that case, if any one of them fails to sign the bill of divorce, it is invalid. Therefore, the sages decreed that the witnesses must sign a bill of divorce together in all cases. Right? Because if the husband use a kind of standardized language of the get, which says all of you are witnesses, and then if they signed at different times, it would definitely render the get invalid. If he didn't use that language, then he could have had them sign at different times. But so as to reduce the amount of confusion about different wordings, different gets being written in different places, they just made a blanket decree. If it's a get, all the witnesses have to be present when the husband writes it and signs it. They have to be there and all sign together. Now, since the Gemara mentioned the law stated by Rabbi Elazar, it analyzes the matter itself. What is it that Rabbi Elazar said? Rabbi Elazar says they deemed the bill of divorce valid only when just one witness is a Samaritan. The Gemara asks, what is he teaching us by this statement? We already learned in the Mishna, any document that has a Samaritan witness on it is invalid except for bills of divorce and bills of manumission. And this indicates that even those are valid only if they have a signature of a Samaritan witness, not two signatures of Samaritans. And the Gemara responds, if it is learned from the Mishnah alone, I would have said that even two Samaritan witnesses are also valid for a bill of divorce or a bill of manumission. And the fact that the Mishnah teaches one witness is because it wants to emphasize that for other documents, even one Samaritan witness will disqualify it. Therefore, Rabbi Elazar comes and teaches us that in the case of bills of divorce, one Samaritan witness is allowed, but not two. And the Gemara asks, and are two Samaritan witnesses not accepted on a bill of divorce? But our Mishnah teaches an incident occurred in which they brought a bill of divorce before Rabban Gamliel in the village of Otnai, and its witnesses were both Samaritan witnesses, and he deemed the bill of divorce valid. So Abaye said that one should teach the Mishnah so that it does not read its witnesses, in this incident of Rabban Gamliel, rather its witness. Right? What they're saying was in that incident, Rabban Gamliel had a Samaritan witness, not two Samaritan witnesses, and that's what he deemed valid. Rava said, actually, no, you don't have to rewrite the Mishnah. You do not need to say that the case was concerning one Samaritan witness, as it indeed is referring to two Samaritan witnesses. And Rabban Gamliel disagrees with the opinion of the first Tana. Rabban Gamliel, minority opinion, allows two Samaritan witnesses, but others don't. And Rabban Gamliel deems valid a bill of divorce that contains two Samaritan signatures, and an incident occurred in which they brought a bill of divorce before Rabban Gamliel in the village of Otnai, and its witnesses were Samaritan witnesses. And he deemed it valid, but the majority would not. And that concludes our discussion of Mishnah number 3. Here's Mishnah number 4. With regard to all documents produced in Gentile courts, even though their signatures are those of Gentiles, they are all valid, except for bills of divorce and bills of manumission. Rabbi Shimon says even these are valid, as these two types of documents are mentioned only when they are prepared by a common person, not in court, right? So we're seeing a couple of things here. First of all, what they said is if it's prepared, a document, any kind of legal document prepared in a court, all right, a proper legal government, authorized government administrated court of the Gentiles, right, of the nations, then we accept that document, except for a bill of divorce or a bill of manumission that has to have, at the very least, one Jewish signature, right? Because we can accept the Samaritan signature, but that's only with regard to Samaritans, right? So let's put Samaritans aside for a second. What we need is Jewish witnesses for a bill of divorce, and Gentile witnesses won't do. That's what we've heard so far, right? Now they're going to make a distinction between courts, right? Gentile courts, and just produced among the Gentiles, as we shall see. Now, with regard to the ruling of the Mishnah, that all documents written in Gentile courts are valid, right, except for bill of divorce and bill of manumission, all other documents are valid. So the Tana of the Mishnah, this is an anonymous Mishnah in terms of the majority, and then Rabbi Shimon has a minority opinion. So the Tana of our Mishnah, right, meaning the majority, categorically teaches a general law in the Mishnah, and it is no different if it is a document concerning a sale, and it is no different if it is a document concerning a gift, that the document is valid in both cases, right? He was distinguishing between all other documents and bills of divorce or bills of manumission to free a slave. So here, what the Gemara is saying, wait, that's odd, because if we're saying that all legal documents produced in Gentile courts are valid, we're surprised that this applies whether the document is a gift or is a sale. Why? And the Gemara asks, granted, in the case of a sale, this is reasonable, as from when the buyer gave money to the seller in the presence of the Gentile judges, he has acquired the property, since he has performed a kinyan, an act of acquisition, and the document is merely proof for the acquisition. So it must be that he already acquired the property in question, and this document that he brings is just proof that he made an acquisition. The acquisition wasn't made via the document. The document attests that the acquisition happened. What was the acquisition based on? Money changed hands. As if he had not given money in their presence, the court would not act to its own detriment, and write a document for him, as the document detailing the sale would not be accurate, and writing such a document would reflect poorly on the Gentile court. Therefore, the document clearly serves as proof that the acquisition was performed in the correct manner. However, with regard to a gift, by what means does the one who receives the gift acquire it from the giver? It is not via this document. Or rather, is it not via this document? And yet, this document is merely a shard, like a shard of pottery, broken pottery. It's meaningless. As a document written by Gentiles is not considered a legal document according to Jewish law. So Shmuel said, a very famous statement that comes up very often in the Talmud, Dina de Malchusa Dina. Dina de Malchusa Dina. The law of the kingdom is the law, right? We might have differences in Jewish law versus the secular law of the country where we reside. But it is a Jewish law that Jews in any country where they're living must follow the law of the land, right? Unless the law of the land contradicts Torah. Like if the law of the land says that everyone in that land has to bow to an idol, no, we don't bow to an idol because a Jew will never bow to an idol. But short of something like that, right, if the law of the land is that in order to get a mortgage, you have to produce, an escrow account and bring a lawyer and all the various secular laws that have to do with real estate or with criminal law, whatever the law of the land is, it's a Jewish law that we are subject to the law of the land, the law of the kingdom, right? So why are you going to say that in the case of a gift, which is evidenced by this court document from a Gentile court, that document is meaningless, right? That was the argument that was being made. Because when there was a sale, okay, money changed hands. That's how the land was acquired. And then the document from the Gentile court is just proof that happened. Whereas in the case of a gift, it's like when that document changes hands and saying, I hereby give you this land as stated in this document, that the transfer of the document is itself the act of acquisition. And normally under Jewish law, such a document signed by non-Jews would not work, right? It would not work. However, Shmuel is saying, well, since the law of the land is the law, we're going to accept that document from the Gentile court signed by Gentiles, even in the case of a gift. And if you wish, say that one should amend the text of the Mishna and teach they are all valid, except for documents that are like bills of divorce. In other words, the distinction is between types of documents. Documents that are meant to serve only as proof that a transfer or a change of status happened, these documents are valid even if they were produced in Gentile courts. Whereas documents that effect a legal act in themselves, such as a bill of divorce, right? Because when the woman receives the bill of divorce, it's at that moment that she becomes divorced. These are invalid if they were written in a Gentile court, suggests the Gemara here. Now, the Mishnah taught that Rabbi Shimon says, even these bills of divorce and bills of manumission to free a slave, they are valid if they were written in a Gentile court and signed by Gentiles. And the Gemara asks, how can Rabbi Shimon rule in this manner? But Gentiles are not fit for this role, as they are not subject to the laws concerning scrolls of severance. Since the halachas, since the Jewish law of marriage and divorce in the Torah is stated exclusively with regard to Jews, right? Jewish marriage law only applies to Jews. So how can you have a secular divorce that's going to affect divorce under Jewish law if when that secular divorce was created in a Gentile court, the judge and the lawyers and the stenographer and everybody who was present there could care less about Jewish law? It's not their affair. It doesn't interest them. They're not subject to it. They're not ruled by it. They're not a Torah-based court. They're a court based in their nation under their law. So they have no reason to care about Jewish law. So in that case, how can you say that a bill of divorce produced in a Gentile court is going to affect a divorce under Jewish law? That's very problematic. Rabbi Zera says, so how could Rabbi Shimon say that? So Rabbi Zera says, Rabbi Shimon follows the opinion of Rabbi Elazar, who says that the witnesses of the transmission of the bill of divorce affect the divorce. In other words, the signing of the bill of divorce is not essential to its effectiveness. Rather, the transfer of the bill of divorce completes the act of divorce, and therefore no attention is paid to who the signatories are. Right? So according to this opinion, the way Rabbi Zera explains Rabbi Shimon and Rabbi Elazar is to say that, well, okay, the bill of divorce was written in a Gentile court, and so it was witnessed by Gentiles. But it was written, right, on behalf of the husband who wants to divorce his wife. Now, he takes that document, even though it was signed by Gentiles, but when it gets delivered to his wife, that action, which is what actually creates the divorce, not the writing. You need a valid get, but what actually creates the divorce is when the get is handed to the wife. And that action, handing the get to the wife, has to be done in front of Jewish witnesses, right? So it doesn't matter that it was written in a Gentile court, because what affects the divorce is the transmission of the get to her, and that must be witnessed by 2 or more Jewish witnesses. Now the Gemara raises a difficulty with this explanation. But doesn't Rabbi Abba say that although he considers a bill of divorce valid, even without the signature of witnesses, right? Because it's the transfer of the get to the wife. So even if when the husband wrote the get, there were no witnesses, in some opinions, that's still a valid get when it gets handed to the wife in the presence of witnesses. Right? So Rabbi Abba doesn't Rabbi Abba say that although he considers a bill of divorce valid even without signature of witnesses at the time of its writing, Rabbi Elazar concedes with regard to a document whose falsification is inherent in it, that it is invalid despite the fact that it was properly transferred. In other words, you don't need, according to this opinion, you don't need to have a signed get, right? That when the husband wrote the get, he doesn't have to have witnesses signing it. There just have to be witnesses present when that get is handed to the wife. But if there was some kind of a lie in the get, right? Or he forged the signatures of witnesses, or a witness lied that he was there when he wasn't there, or a witness changed his name. If there was some kind of falsification at the time that the get was written with respect to the witnesses or the alleged witnesses, then it is an invalid get. Even though the witness signatures are not essential to the get, if there's something false about them, that invalidates the get. In other words, notwithstanding the law that the signatures on a bill of divorce are unnecessary, a document that includes invalid signatures is thereby invalidated. So the reason is that there is a concern that people will rely upon these witnesses. And the Gemara answers with, what are we dealing here? Now we're in 11a. We are dealing with unambiguous Gentile names, in which case there is no need to be concerned that people might rely on these individuals as witnesses for the transfer, as it is evident that they are Gentiles, right? So what we're getting at here is, what do we say? Not necessary, maybe, at least under some opinions, to have Jewish witnesses when the get is written. Definitely necessary to have Jewish witnesses when the get is delivered to the wife. If you find witnesses on the get and you assume that they're Jewish, and they might not be, because maybe, by their names you can't tell. I had a good friend in college whose name was Peter Miller. Is Peter Miller Jewish? I don't know. I mean, he happened to be, yes, he was a kippah-wearing Orthodox Jew. But I'm sure there's many Peter Millers who are not Jewish. But if a guy's name is, Yankee Bernowitz, okay, he's probably Jewish, right? And if his name is, Charles Emerson Winchester III, he's probably not Jewish, right? So there we're talking about unambiguous Gentile names, and even more so if somebody is named, Tom Asherah tree, right, which was an object of idolatry in the ancient world. Like if somebody's actually named after an idol, okay, so that person's like not going to be a Jew. That would be an unambiguous Gentile name. So in that case, we're not going to worry that somebody's going to make a mistake and ask the unambiguously Gentile to be the witness when the get is delivered to the wife, because they might not realize that even though that person might be permitted to be a witness for the signing of the get, but he won't be permitted to act as a witness for the delivery of the get. The Gemara clarifies, what are the circumstances of unambiguous Gentile names? And Rav Papa said this is referring to names such as Hurmes and Abudina and Bar Shibetai and Bar Kidri and Bati and Nakim Una. Right, all names that in that culture at that time of the Talmud, like if you heard that name, that was like obviously not a Jew. Now the Gemara infers, however, if the bill of divorce or the bill of manumission was signed by Gentile witnesses with ambiguous names, right, where they could be Jewish, they might be Jewish, they might not be Jewish. What is the law? Is this not a valid document? If so, instead of teaching in the latter clause of the Mishnah, these two types of documents are mentioned only when they are prepared by a common person, not in court, so let him distinguish and teach the distinction within the case of Gentile courts itself, like this. In what case is this statement that Gentile signatures are valid for a bill of divorce or manumission said with regard to unambiguous Gentile names? However, in a case of ambiguous names, no, Gentile witnesses are not valid lest the people involved in creating this divorce make a mistake and use this Gentile who is there for the signing of the document to also be the witness when it is delivered. Now the Gemara answers, well, that is also what he is saying. Meaning Rabbi Shimon's statement that these bills of divorce and bills of manumission are also valid should be understood exactly like you're saying. In what case is this statement said? With regard to unambiguous Gentile names. However, with regard to ambiguous names, we're not sure if he's Jewish or not Jewish, the document becomes like one that was prepared by a common person, and therefore such documents are invalid, right? Even where we allow Gentile signatures on the get when it is written, it's only when it was written in a Gentile court where we have reason to believe that there are safeguards and measures that whatever's being written there is authentic and that the husband himself created that get and signed it. But if it was just written by Gentiles, willy-nilly on their dining room table, then no, we don't accept that get. And if you wish, say a different answer in the last clause of the Mishnah, which states these types of documents are mentioned only when they're prepared by a common person as opposed to a court. We are no longer discussing bills of divorce. Rather, we arrive at the case of financial documents. Furthermore, this clause of the Mishnah is not a continuation of Rabbi Shimon's statement, as it returns to the opinion of the first Tana. And this is what the Mishnah is saying. Financial documents are mentioned as invalid only when they were prepared by a common person, whereas if they were produced by a court, they are valid. Because Dina de Malchusa Dina, the law of the land is the law. And we respect the Gentile court. But as for Gentiles, who are unknown to us, we can't rely on that. So it is taught in a Baraisa. Rabbi Elazar, the son of Rabbi Yosef, said that Rabbi Shimon said this to the sages in the city of Tzaidan. Rabbi Akiva and the rabbis did not disagree with regard to all documents produced in Gentile courts, that even though their signatories are Gentiles, these documents are valid. Even in the case of bills of divorce and bills of manumission, where did they disagree was only when they were prepared by a common person outside of a court. As in that situation, Rabbi Akiva deems a document of this kind valid. Right, so Rabbi Akiva is willing to trust a financial document or a bill of divorce or bill of manumission valid with Gentile signatures. However, he was in the minority on that, and the rabbis deem it invalid except for bills of divorce and bills of manumission. So because really it doesn't matter who witnessed the signing. What really matters is who witnesses the delivery. Now, Rabbi Shimon ben Gamliel says even these bills of divorce and manumission are valid in a place where Jews do not sign. In other words, the law that a document with Gentile signatures is valid, this applies only in a place where Jews are not allowed to sign financial documents. You could imagine, late 1930s Germany. I don't even know if this was one of the restrictions that the Nazis passed. Certainly Jews were not allowed to hold jobs in like any government position and most kinds of jobs. And perhaps another right that they stripped, and that they certainly did strip in ancient times from Jews in various communities in other countries, was that they would not be allowed to sign financial documents. So, and that's it. Why? For it to be a valid document, they're going to have to go pay some Gentile or some, officer of the court a fee. It was a way to make money off the Jews and to denigrate the Jews. But that happened at certain times. So in that situation, okay, we're going to accept Gentile signatures on financial documents and bills of divorce, etc. But where Jews are allowed to sign, then that's what we want. We want people for the Jewish community familiar with Jewish law that is going to govern these contracts to sign the contracts. So the Gemara suggests, okay, so if that is the case, let us also decree in a place where Jews do not sign, due to a place where Jews do sign. So the Gemara answers, in other words, now we're creating confusion that, we're going to have a different requirement for financial documents and bills of divorce in places where the Jews are being oppressed versus in places where they're not. Isn't that going to proliferate confusion across the Jewish world? So the Gemara answers, well, one might confuse one name with another name. It is possible that one might think that a certain name is that of a Jew when it is actually that of a Gentile. However, one is not likely to confuse one place with another place, since everyone knows that all the signatures in a certain place belong to Gentiles because Jews aren't allowed to sign there. So they're going to be careful not to transfer a bill of divorce in the presence of witnesses who signed it, unless they are certain that the witnesses are Jews, right? Because again, the divorce, even if it's in a place where Jews are not allowed to sign documents, the transfer of the get that was signed by the husband to the wife has to be done in the presence of Jewish witnesses. And if it's a place where Jews are not allowed to sign documents, we're going to be careful to get Jewish witnesses for that delivery and not rely on whoever might be named as witnesses in the get. So the Gemara relates an incident. Ravina thought to deem valid a document that was written by a group of Gentiles. And Raphaim said to him that we learned Gentile courts in the Mishna, i.e. these documents are valid only if they were produced in an important court, not by any random group of Gentiles. And similarly, Rava said with regard to this Persian document written by the Persian authorities that was transferred to the recipient in the presence of Jewish witnesses, he can collect with it non-liened property, i.e. property that is unencumbered by a mortgage. Although this is not considered a proper document by means of which one can collect from any land sold by the debtor, like including mortgage land, nevertheless, the facts in the document are considered accurate, and therefore one may at least collect non-mortgaged property with it. So the Gemara asks, but the witnesses for the transmission of this document do not know how to read Persian, as most Jews did not read that language. So if so, how can they serve as witnesses? And the Gemara answers, Rava is referring to a situation where these Jewish witnesses know how to read Persian. So the Gemara questions how the court can rely on such a document. But I require that the document be written in a manner that cannot be forged. And it is not so in this document, as the Persians were not particular about preparing their documents in this manner when writing their legal documents. They did not have the same standards for legal documents that the Jewish community had. The Jewish community had higher requirements, right? Like they had to be notarized. The Persians didn't require notarization. I'm just saying that as an example of enhanced legal safeguards that Jewish courts had that the Persian courts didn't. So how can you rely on the document produced in a Persian court that was held to a lower standard? And the Gemara explains, Rava's statement applies in a case where the paper of the documents was processed with gall. Consequently, it is not possible to forge the writing. But I require that a document review the essential topic of the document in its last line, and it is not so in the case of Persian documents. So the Gemara answers, Rava's statement applies in a case where it returned to review the essential topic of the document in the final line. In other words, they're going to do away with the objections. Right? In other words, you can say, well, how can you rely on Persian authorities and Persian signatures and Persian witnesses when they have lower standards? And they're going to say, okay, we're only talking about cases where the document in question was written up to the standard that we would need for Jewish law. In that case, we would allow the Persians to be witnesses. Now the Gemara asks, okay, if so, he should be able to collect from mortgage property as well. If you're saying that the document is in every way the equivalent of a document under Jewish law, why are you only going to allow the bearer of that document to collect non-mortgage property? If it's a valid document, then he should be able to collect mortgage property as well. Why doesn't Rava say that it can be used to collect from liened property as well as any property? And the Gemara answers, the reason is that this document does not generate publicity, i.e. a legal matter that is performed in a Persian court will not become publicized among the Jews. Therefore, this case is similar to a loan by oral agreement where the transaction is not publicized. In this case, the lender can collect only from non-liened property, as purchasers from the debtor would not have been aware of his debt and consequently taken sufficient measures to ensure that the property would not be claimed from their purchase. Obviously, we're in a whole other area of law that we're going to come to in a few tractates down the line, so we're not going to get into the nitty-gritty of what constitutes a valid purchase agreement, a valid loan agreement, a valid etc. Here we're just talking about that the Persians and the Jewish community in Persia had different standards and how we dealt with that. Now, Reish Lakish raised a dilemma before Rabbi Yochanan. Now we're on 11b. With regard to witnesses who signed a bill of divorce and whose names are like the names of Gentiles, what is the law? So Rabbi Yochanan said to him, there came before us bills of divorce that were signed only with names such as Lukos and Los, and we deem them valid by means of the witnesses of transmission. We can't be sure that the witnesses who signed that get were Jewish, but we ratified the transfer of the get because that was done in the presence of Jewish witnesses. So the Gemara infers, and this applies specifically to names like Lukos and Los, as it is uncommon to find Jews who are called by these names. However, with regard to other Gentile names, concerning which it is common to find Jews who are called by these names, no, the documents are not valid, as people might mistakenly rely on the signatures of Gentiles, right? Because the names are ambiguous, right? And you're not sure whether the person in question is a Jew or a not Jew. We're going to invalidate the document lest, the people transferring the get to the wife, rely on the presence of the people who signed the get to be there when it was given to her. Because remember, it's not always the case that a get is written, where the husband is and then delivered by somebody to the wife, in another town on another day. Very often is the case that the husband and wife do come together in the same room, and the people who witness the signing of the get are the same people who witness the giving of the get to the wife. And if those people are not Jews, then this whole process is no good. She's not divorced. Reish Lakish raised an objection to this ruling from a Baraisa Tosefta 4:8 with regard to bills of divorce that come from a country overseas and witnesses are signed upon them. Even though the names of the witnesses are like the names of Gentiles, they are valid because the names of most Jews outside of Eretz Yisrael are like the names of Gentiles. They could even be named Salvador, very Gentile name. And this indicates that a bill of divorce is valid even when the names are not clearly those of Gentiles. And the Gemara answers, well, there the law is different, as it teaches the reason explicitly. Because the names of most Jews outside of Eretz Yisrael are like the names of Gentiles. Consequently, it can be assumed that the court examined the matter at the time of the signing and that the document was signed by Jews. However, in Eretz Yisrael, it is more likely that ambiguous names are actually those of Gentiles, because most Jews have clearly Jewish names. in the land of Israel back then, and therefore a document of this kind is valid only when it is clear that it was signed by Gentiles to avoid mistakes when they might rely on the Gentiles to witness the transfer of the get. And this was one version of the discussion. And there are those who say that Reish Lakish asked Rabbi Yochanan about the very same case as in the Baraisa, and he resolved the matter for him from the Baraisa, that even if the names signed on a bill of divorce brought from outside of Eretz Yisrael are like the names of Gentiles, they are valid. And that concludes our discussion of Mishnah number 4. And now I'm going to read to you Mishnah number 5, and with that we're going to conclude today, and we'll continue the discussion of the Gemara of Mishnah number 5 tomorrow. So I'm almost done. Get your questions and comments in. Here's Mishnah number 5 here in chapter 1. With regard to one who says to another, give this bill of divorce to my wife, or give this bill of manumission to my slave, if before the document reaches the woman or the slave and the giver wishes to retract his decision, if he wishes to retract his decision, then with regard to both of them, the bill of divorce or the bill of manumission, he can retract. This is the statement of Rabbi Meir. And the rabbis say, right, so the majority who disagree with Rabbi Meir say, one can retract his decision in the case of bills of divorce before the get reaches her. But in the case of bills of manumission to free a slave, no, he can't retract. Once he gives it to the agent of delivery, that slave is going to be free. He might not be technically free until he receives it, but the master who's freeing him can no longer retract his decision. And the rabbis explain the reason for their ruling. This is because one can act in a person's interest in his absence. And therefore, the agent acquires the document on behalf of the slave from the moment that the owner hands the bill of manumission to the agent. But one can act to a person's detriment only in his presence. So the receipt of a bill of divorce is considered to be to a woman's detriment. She doesn't gain when she's divorced. Therefore, the agent cannot receive it on her behalf. She's not deemed to have received it until she receives it. Right? Whereas the slave, because becoming free is always going to be a gain, right? Is it? But think about it. But the basic idea is for a slave to be freed is certainly to his benefit. Therefore, as soon as the master hands the bill of manumission to the agent of delivery, that agent receives the bill of manumission on behalf of the slave, and the slave is free from that moment. But not so in the case of an agent of delivery for the woman, because, it's a detriment to her to become divorced. Therefore, she doesn't actually get the get until it's handed to her. Or at least to an agent that she appoints for that purpose, that she appoints, right? Whereas the husband appointed the agent of delivery. Now, they explain further, the emancipation of a slave is in his interest, despite the fact that he receives sustenance from his master while a slave, as if the master wishes not to sustain his slave, he is allowed not to provide him with sustenance. The master could say to the slave, you're my slave, and go ahead, grow your own food, Interesting. This demonstrates that slavery is not in the interest of the slave, as he does not receive any guaranteed benefit. But if a husband wishes not to sustain his wife, he is not allowed to proceed in this manner. He is obligated to sustain his wife. Consequently, marriage is in the interest of the woman. So Rabbi Meir answered the rabbis, but you haven't considered something. Even so, it is not in the interest of a slave to be emancipated, not in all cases, as if his master is a Cohen, if his master is a priest, so he disqualifies his slave from partaking of teruma, right, consecrated food when he emancipates him, right? A non-Cohen, a Jew who is not a Cohen, like a Levite like me or an Israelite or anyone else, we cannot eat teruma. Only priests can eat teruma, consecrated food for the benefit of priests. But the slave of a priest, even if he's not a Jew, can eat teruma because he's the member of the household of a priest. When the priest frees him, he can no longer eat teruma. So that would be a detriment to the slave. Based on that logic, Rabbi Meir is saying, how can you say that the slave becomes free as soon as the master hands the bill of manumission to the master's own agent? How can that agent acquire the bill of manumission on behalf of the slave if you can only acquire on someone else's behalf without their knowledge if it's to their benefit, but not if it's to their detriment? And here we've identified a detriment to the slave. And the rabbi said to Rabbi Meir, it is permitted for a priest's slave to partake of teruma, not because he has a right of sustenance, but rather because he is his master's property, his master's acquisition. Okay, so he can eat teruma while he lives in his master's house, but he has no right to teruma. He's just allowed to eat it while he's there. So it's not such a detriment that we're not going to, allow the agent to accept the bill of manumission on the slave's behalf, because, as logic dictates, it's always to the immense benefit of the slave to become free. Now, I bet they'll challenge that with other kinds of examples when we continue our discussion of Mishnah number 5 here in chapter 1. Okay, time for a couple of questions on Gittin 10 and 11. Waiting for the document to load. Jonathan, the issue about signing the bill of divorce made me think this. How often do we sign things we really don't understand? If we have apps on our phone, constantly, right? I mean, don't we all sign the terms of service without reading them? In the case of a Samaritan or other, the Gemara and the Mishna make it clear that witnesses need to understand what they are signing and what is going on. They aren't just signing to say, yeah, I was there, they said stuff, but I didn't really understand. One has to add value by understanding, right? And we saw that if the witness was illiterate, we might help him stencil his name, but he's only allowed to do that and to sign, his mark, as it were, after the document is read to him so that he has heard it. So good point, Jonathan. Sharon, were signatories paid for their services? I do not know. It's a great question. I do not know. Sharon, if they had to affirm that it was written and witnessed in their presence, and now we are told the writing and witnessing are unimportant, what was the big deal about the proclamation we were requiring earlier? Well, I think there what matters is that we know that the husband signed it, right? That's what really matters. Because the husband is not going to be present in the land of Israel when the wife is there in front of witnesses to see the signing and the delivery, we want to make sure that that get is actually coming from the husband. And it's not some plot, by, some guy who's really into her to make her think that her husband divorced her so he can move in, right? So we want to make sure that the husband actually wrote that get. So that's why, we require witnesses from abroad. And even if we can say in some cases, if we can ratify, we can have to ratify. No, we require witnesses. Because the husband is not going to be in the land of Israel before a rabbinic court in Israel, that's why we require that he had witnesses and that the agent of delivery can attest it was written in my presence and signed in my presence. When you're talking about the whole thing is happening in Eretz Yisrael, then the witnesses are not as important at the writing, because we have other ways to make sure that the husband really signed it, and we're going to have the witnesses to the delivery. Joseph, if someone had a last name associated with idolatry, could they inquire whether this person's family were exiles who were assimilated, like my family were, possibly Italian conversos as far as I've researched, and would that make a difference? I mean, I'm sure that it would make a difference, right? Like, what we're talking about, I think generally here, is sort of cases after the fact that where the get was created in a way that we can't be sure, right? And so, when we're faced with a get, that has these ambiguous names, and it was written in Israel, right? And what they've said here is most Jews in the land of Israel had unambiguous Jewish names, right? And the Gentiles were the ones who had, unambiguous Gentile names. And then it was usually, if they had an ambiguous name that could be a Jew or a Gentile, that was probably a Gentile. And what they were afraid of is that, they would come to rely on the Gentile witness for witnessing the transfer of the get to the woman. And that's why they prefer not to allow that person to sign. But if you're talking about a Jew who has this ambiguous name, maybe what they would say is, okay, when you sign, and you have a weird name like Salvador, for example, Litvak is a very Jewish name, but if I had, an ambiguously Jewish name like Miller, if my name was Salvador Miller, then maybe they would say, could you sign it Salvador Miller, son of, somebody who has a more Jewish name, if my dad has a more Jewish name, or something like that, or they said, could we find a different witness, so that, because the whole value that's at stake here, right, is creating situations where the wife can rely on the get so that she can remarry and not be concerned that later that get will be challenged and her second marriage will be invalidated. All of these laws are to protect the woman. That's what I've got for us today. With God's help, we're going to be together tomorrow to read the next daf at our regular time, 6 p.m.